IVM.
Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to another episode of All Things Policy. I'm your host Shrikrishna Upadhyaya, and my guest on the show today is Anushka, a researcher with the Indo-Pacific Studies program at Takshashila with a focus on China. Welcome to All Things Policy, Anushka.
Thanks, Shri. Happy to be here.
So, Anushka and I are going to be talking about cyber-enabled intellectual property theft and the role of international law in combating it. Also, we'll be touching upon India's engagement with the issue, what are India's priorities, what steps India can take to secure itself from cyber enabled intellectual property theft. So, Anushka, I believe cyber enabled IP theft has become a key pressing concern, both in terms of economic security as well as overall cyber security for countries these days, especially for governments as well as industry and private sector enterprises. So, could you begin by talking a little bit about what this entails, how big is the problem that we are talking about, what are sort of the factors which help in distinguishing cyber enabled IP theft from any other kind of a cyber attack?
Right. Thanks for that, Shri. I think because we're so used to the notion of intellectual property theft conventionally, the deliberation on the cyber aspect of the stealing of such intellectual property through computerized mechanisms has kind of taken a backseat, especially also considering, and as you mentioned, there is an emphasis on other more visible forms of cyber attacks. So the primary difference, of course, is that in cyber enabled intellectual property theft, computerized mechanisms, electronic mechanisms can be used by actors that are not even based inside the territory of a particular nation state to steal important, commercially sensitive information from computer systems, from online information technology systems, sitting far away, of course. And it could be many years before a particular private entity or a government entity realizes that this intellectual property is stolen, when copies or products built on that intellectual property start resurfacing somewhere else, right? And of course, this differentiates it from other forms of cyber attacks like hacking, phishing, blocking, denial of services, so on and so forth, right? Because their impacts are much more visible in the shorter term, and they'll kind of lead to, for example, malware attacks lead to incidents notifications popping up for those who have already installed a cybersecurity infrastructure, right? But that may not be the case with IP theft. In that sense, because technology and the digital economy is continually evolving, a lot of the intellectual property is now being stored online. And of course, cyber enabled theft of intellectual property has become a big problem, like you said, both for economic security and national security, but has, for the reasons I mentioned, taken a back seat. And as to the question of how big the challenge is, I think I'd like to quote a study by Deloitte here, who published a comprehensive report on how much an incident of cyber IP theft can cause, how much loss can it cause for a firm. And when the study was published a couple years ago, the loss was around $3.2 billion. And this is inclusive of costs because of the lost value of contract revenues, increased costs which are borne by the firms due to litigation and arbitration, attorney fees, as well as the cost that will go into making additional improvements in cybersecurity infrastructure. And there is, of course, the price to be paid for the loss of a first mover's advantage in the market, because you have lost the IP, and the kind of research and development funding you put into creating the IP in the first place can now be used by the actor who stole it, the advanced persistent threat actor, and instead divert their funds only on building it and bringing it to the market. So this should clearly be a priority challenge both for the private sector and the government, given that it has huge numbers attached to it.
Right. So let's talk a little bit about the actors behind this, right? I mean, who are these cyber criminals? Are these individuals? Are these international crime organizations? Are these state sponsored attacks? And what are some of the motivations that could propel them to carry out such IP theft, right? Is it just purely financial gain, or do you think there is something more sinister at play? What's the story there?
I think that's a very thought provoking question, because attribution for crimes like IP theft, or even for other forms of cyber attacks, is very hard and complicated. It's a very hard and complicated process, because using the cyberspace for criminality has the advantage of course, anonymity, and now tools have become more sophisticated, and it's, it can be all of those actors that you stated. It can be international criminal syndicates, so cyber apts that operate internationally. It can be state sponsored cyber criminals, but the only challenge with, of course, again, attributing anything to a state is that it will rarely be official. It will be done by cybersecurity firms like Pharma or Recorded Future. A lot of the cyber attacks that have taken place in the Indian territory, including attacks that led to loss of economic information, like the attack that took place against Air India, where the in 2021, where information of many thousands of customers was lost. The personal and commercially sensitive information was also attributed to this APT, to this advanced persistent threat actor called APT 41, which is again believed to be connected with the Chinese Ministry of State Security. So this kind of attribution to a state sponsored actor is again done by firms like Recorded Future and Pharma, even some of the risk intelligence and consulting businesses like Deloitte. So it can be any of these actors. Usually, cyber enabled theft of intellectual property takes a lot of sophistication and investment, and private threat actors like criminal syndicates would rarely have incentive to do it. So largely it could be state actors and state sponsored apts that are responsible for this.
Right, and let's talk a little bit about the regulatory provisions first at the international level and later on at the domestic level. Let's begin with the international law provisions relating to tackling such cyber-enabled IP theft. So, first of all, are there any provisions at all under international law? Second, who are sort of the agencies or multilateral organizations who have been tasked with enforcing such law? And third, what are your comments on the effectiveness of these provisions?
Right. So, sorry, and just to quickly answer one of the questions you'd previously asked about the incentives to do this, incentives to engage in cyber enabled IP theft, before I can move on to the question about multilateral regimes. I think in flowing from the argument about how these are mostly state sponsored, the incentives are pretty clear, right? It's, of course, stealing of IP from a firm that is placed abroad. So, as an example, Chinese state-sponsored APT stealing IP from a US firm. It will lead to the Chinese state or any actor associated with the Chinese state, or even with the APT, gaining a significant market advantage. Because, like I said earlier as well, investing in IP and creating IP requires an R&D fund of its own, but building on IP requires much less of a fund, because the real challenge is creating something unique and innovative in the first place. And so if somebody's already created it, you can either engage in forced technology transfer, or you can just steal it anonymously and secretly. And so I think IP theft has great advantage in that. Cyber enabled IP theft in particular has great advantage in that regard, because it helps you with distributing funds in only building upon the already created IP, gaining a first mover's advantage in the market. And of course, it has an abstract value in the sense that it enables devaluation of your market adversary. So if a firm conducts cyber enabled IP theft against another one, it's so that their competitor is at a loss. And now, talking about the multilateral regimes, I think in general, espionage during war is governed in international law. The Geneva Conventions, of course, govern it. There is a lot of legal commentary on how those who engage in espionage during war are to be treated in international law. They're supposed to be treated as prisoners of war if they are captured, and overall it isn't considered illegal, right? But like everything else pertaining to the cyberspace, international law is very vague and unclear about cyber enabled IP theft in specific. In fact, there is no mention of it at all in any of the most universal arrangements except for the G7 and the G20. um, so some of the meetings of the G7 and the G20 in the past few years have seen an agreement uh, in which the nation states come together to condemn the stealing of intellectual property using cyber means. And the and I think in 2017 the G7's Information and Communications Technology and Industry Ministers Declaration said in its 57th article that no country should conduct or support ICT enabled infringement or misappropriation of intellectual property with the intent of providing competitive advantage to companies or commercial sectors. And so I think that agreement between the world's largest economies exists. And so that provides for some certain worded multilateral agreement on cyber enabled IP theft. But otherwise, the arrangements that exist under the World Intellectual Property Organization and the World Trade Organization, more specifically the TRIPS agreement, right? Some of its provisions can be interpreted to be applicable to cyber enabled IP theft. So, just quickly, TRIPS is the agreement on trade related aspects of intellectual property rights. And for example, Article 39 of the TRIPS agreement says that all states should protect secret and sensitive, commercially valuable intellectual property and information of the natural and legal persons within their member states. And so naturally, if a state has a responsibility to protect the IP of private firms or any other actor within their territory, a natural or legal person, so to say, then of course cyber enabled IP theft should be a part of it. But my thoughts on that is that legal scholarship is divided. On the one hand, some argue that this is espionage and it should be allowed. On the other, some argue that the provisions of the World Intellectual Property Organization and the World Trade Organization are only applicable to IP theft between the natural and legal persons within a country and not necessarily between two countries. And so it doesn't have an international character to it. And some say that the language within these agreements, like the Paris Convention of the World Intellectual Property Organization or the TRIPS agreement, is deliberately written this way, deliberately vague, so that it can be interpreted however it wants by member states. And so, according to whatever is written in the TRIPS agreement, countries should have the option to go to the dispute resolution body of the WTO and claim protection against it. But that accounts for challenges of its own, because then that would require for you to invest in attribution to a state. So my opinion definitely is that these provisions do account for states to go to the WTO under the TRIPS agreement and seek resolution. But for that, the major challenge they have to overcome is that they have to attribute first, find the incident of cyber enabled IP theft, and then attribute it to a state.
Stay tuned to All Things Policy. We'll be right back after a short commercial break. Yeah, Anushka, I think you're very right in pointing out that attribution remains the biggest challenge as far as tackling cyber enabled crimes such as IP theft is considered. I'm just thinking out aloud here, like, is cyber espionage still in violation of the principles of non intervention, which are encoded within the UN Charter? Is there a reasonable case to be made out that, at least, let's assuming, of course, that a state is attributable for the actors who indulge in a particular IP theft, so that attribution leg is established. After that, do you think there's a reasonable case to be made that this somehow falls within the ambit of non-intervention, and a state can be held accountable under international law for having exceeded its exceeded its brief as far as enabling such crimes is concerned.
That's definitely an interesting aspect to think about, because, again, like with any evolving legal scholarship on the applicability of international law in cyberspace, this too has contending schools of thought. And the Tal Manual 2.0 in specific, which is huge book that brings together thoughts, ideas, and best practices from various legal scholars, international legal scholars, on how cyberspace deploys international law. As per the second Tal manual, cyber enabled IP theft does not in particular constitute a violation of the sovereignty and the territorial integrity of a nation state, because they contend, the scholars who've drafted the manual contend, that stealing of IP and commercially viable data from the territory of a country that other than the one that it is originating from, it does not intrude the physical territory of said country, and it does not cause any harm or damage to critical information infrastructure. So, again, the clear challenge here is that we are very short sighted in looking at this, because the harm and the damage isn't immediate, and it is not to critical information infrastructure in particular, but to the larger economy. And so this is also ironic, considering the second rule of the Talent Manual explicitly says that a state enjoys sovereign authority with regards to any cyber infrastructure or cyber activities located within its territory, right? So it leads one to conclude that while the drafters of the manual agree that states have a right to exercise sovereign authority over any and all cyber infrastructure within their territory, um, they still should disregard any cyber espionage or cyber enabled IP theft as a violation of territorial integrity under Article 2, Subclause 4 of the UN Charter. And so this is ironic, and this does not necessarily mean that cyber espionage, but yes, the manual does clarify, and it does not necessarily mean the cyber espionage in itself is unlawful, but means of conducting such espionage may be unlawful in international law. So it leaves that vague sort of space for states to draw legal scholarship from. But yes, the other side of this view is that state practice, which is one of the most important and fundamental indicators of international legal practice, it is one of the sources of international law. We know that from the statute of the International Court of Justice. State practice indicates that countries do not appreciate cyber espionage operations, and so naturally cyber enabled IP theft is not appreciated as well, and they consider such acts violation of their sovereignty and territorial integrity, right? One of the examples is when the US National Security Agency was conducting some cyber espionage operations to access secret data and steal it in the aftermath of the Edward Snowden controversy in 2013. Some of the countries of Latin America sent a letter to the UN Secretary General condemning acts of the United States' National Security Agency and calling it a violation of their sovereignty. I think the need of the hour, of course, is for countries to develop their own state practices and to interpret for themselves whether they believe how the international law applies to cyber-enabled IP theft, and whether they believe that it is a violation of sovereignty or not. But I am particularly more inclined to the latter argument, that state practice indicates that it is considered a violation of territorial integrity, also because there is irony and there are gaps in the Talent Manual's interpretation as well.
Yeah, right. So, from whatever you've spoken so far, I sort of get the impression that international law, all said and done, is still inadequate and has miles to go before it can, provide robust protection in this regard. Let's move on to a sort of domestic situation, particularly here in India. So, India is a large growing economy. It is vulnerable. It's got its enemy. India's IP can of course be misused for various means, like you pointed out earlier. There was this whole case about Air India and so on. So could you sort of elaborate the situation, the threat scenario that India faces currently as regards cyber-enabled IP theft, and maybe talk about a few more other examples so that you can drive home the severity of the problem?
In just like you pointed out about the gaps in the loopholes in international law, and of course the inadequacy, we have a similar situation here domestically, in that we do not have specified definitions or provisions for the protection of firms and economically sensitive information against cyber enabled IP theft in specific. Under the Information Technology Act, the amended one from 2008, there are provisions on use of computer and electronic devices for theft of identity, for potential surveillance, for stealing of personally sensitive data, and for, of course, using computers for any other illegal means that may not necessarily be listed in the IT Act, but can constitute a violation of, say, right to privacy or anything of the sort. So yes, of course, if one really is able to discover cyber-enabled IP theft, they can use some provisions of the IT Act, albeit vaguely, to be able to claim redressal and redressal of their grievances. But yes, overall, I think in India, the challenge, like for many other states, is attribution. Of course, US, Japan, and other countries in Europe, together at the EU level, are now practicing attribution. Clearly, in fact, the US has conducted attribution for cyber enabled IP theft attacks India has faced from China. So I think there is. At the state level, the practice of attribution has already begun, because attribution is the first step to identifying the APT and the challenger, and then eventually going for dispute resolution against them. And so in India, I think some of the key cases, in addition to the one from Air India, is the attack that was faced by the Kurnakulam nuclear power plant in Tamil Nadu, where it was alleged that a North Korean IP theft actor, which is the Lazarus Group, had infiltrated the nuclear power plant's systems and wanted to steal commercially sensitive information regarding the development of nuclear power and weapons. Right, and of course, we know North Korea to be a hostile actor when it comes to the use of nuclear weapons, and so again. With this also, along with attribution, another challenge we faced when this incident was occurring, that some of the governmental authorities refused to identify that such an attack is even taking place, right? 29th October, they completely refused that the attack happened, some 29th October in 2019, I think. And on 30th October, they put out another press release and said that no, this attack indeed happened, right? And these notifications were put forward by CERTIN, which is the Indian Computer Emergency Response Team, which is tasked with the responsibility of reporting incidents of any cyber intrusions and attacks, and suggesting a way forward. And so one day the CERTIN was dismissing this information as disinformation, and the next day they were claiming that yes, this indeed has happened. And of course, even then there was no attribution to North Korea. So I think on the domestic level, there has to be an assessment uh, of not only the severity of the challenge from actors like North Korea and China, but also of being candid, right? That this attack has indeed happened. These are the first responses that we should make against it, because the actions of the CERTIN really delayed the action against the malware, and then eventually moving forward to dispute resolution.
Right. And of course, India has a major threat factor, which you so clearly pointed out. And earlier you had mentioned about how G20 has seen some developments in this regard. So, a final question to you before we close. I want to know from you if India can sort of like take positions, advocate policy at the international level at various forums, G20 and otherwise, so as to come up with a legal framework which will enable countries to cooperate much better when it comes to holding holding actors accountable for cyber IP thefts.
Right. Yeah, that's definitely a very interesting proposition. And I think G20, as I mentioned earlier, was one of the first multilateral entities to acknowledge cyber enabled IP theft in those exact words. In 2015, their joint communique explicitly stated that countries affirm that no other countries should conduct or support ICT enabled theft of intellectual property, including trade secrets or other confidential business information. Same with the intent of providing competitive advantage. And slowly since 2015, this phrase has kind of vanished, and it was nowhere to be seen in 2023 as well, when India was president of the G20. And so I think there is definitely a case to be made for India to advocate for this, but at the same time, that would also require an inward looking attitude as to defining cyber enabled IP theft in our own legal practice, and also helping firms do better reportage, right? Often in India, it is observed that firms do not report cyber attacks due to the fear of loss of valuation or due to the fear of inviting regulatory action. And so making reportage easier is equally important. And once all of these things are in place, India can go ahead and advocate it multilaterally. But yes, some of the other regional organizations that are kind of looking at this in addition to the G20 and the G7 are a body of the Asia Pacific Economic Cooperation Grouping, which is the Intellectual Property Rights Experts Group, which tries to create interoperability within APEC countries on countering IP theft in general and cyber theft in specific. And also to maintain kind of uniformity in how APEC members interpret the TRIPS agreement to hold other members accountable for cyber IP theft. The EU Intellectual Property Office also has published a report making an assessment of the IP threat environment. And it's not just on conventional IP theft, but also IP infringement methods that use cyber means like cyber squatting or cyber sale of counterfeit products, which are all part of stealing of IP using cyber means. So the EU and the APEC have set some examples that India can learn from. The United Nations Office on Drugs and Crime, it has also developed a cybercrime module, which is on understanding the reasons why firms and individuals may engage in IP-related cybercrimes. So alluding to your earlier question, if listeners do want to know on the incentives to do this and how they can be deterred through domestic and multilateral legal regimes, one only has to refer to this cybercrime module. So yes, there is some understanding that in the multilateral and international sphere that this is a challenge. Some resolution mechanisms exist as well. And I think India would just have to seize the moment in that, right?
Right. All right. Thank you so much, Anushka, for joining me on this episode of All Things Policy. And to our listeners, this is our last episode for 2023. It's been a great year. We managed to bring you our podcast on a daily basis, the world's only daily public policy podcast. So thank you for listening in. We'll be back on the 2nd of January with a special episode where the members of Takshashila Institution will be putting forth their predictions for the new year 2024. So thank you once again, Anushka, for joining me.
Thanks, Sri. Delighted to have this be the last podcast. I hope the listeners enjoy listening to it, and please do tune in next year for another episode.
Right. And before I let you all go, I want to remind our listeners that the applications for the Graduate Certificate in Public Policy, 3-month flagship public policy program offered by the Takshashila Institution, are closing on December 31st. The January cohort will begin from Jan 13. So if you're sitting on your applications, please fill them as soon as possible. And it might just be the perfect New Year gift to some loved one as well. So thanks once again for listening, and stay tuned to All Things Policy.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, If you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.